Hi, this is Kelly Riddle. Appreciate you joining me for the PI and the law. So understand first off this disclaimer, I'm not an attorney. This is just a review of case law and situations that a PI will find themselves in. I was at a conference speaking at the Texas Association of Licensed Investigators some time back, and one of the newspapers had done an interview with me. And on the front page, they misquoted me. I'm very cautious, especially when I talk to the media and it has to do with bug sweeps. We do electronic bug sweeps. And in this particular case, they interviewed me about that topic and I told them very specifically, we do not put bugs anywhere. We find them. Well, on the front page, it said, and Mr. Riddle says that he puts bugs in blah, blah, blah. So everybody's walking around, so you put bugs in places, huh? Well, on the bottom of that article was an interview with a PI supposedly from California. He stated that he loves doing surveillance at night because he always sneaks up to the car, drills a little bitty hole in the tail light so that that white will shine through the red light. So I'm hoping that he was misquoted as well. But that's the kind of stuff that we have to be cautious about. They're breaking of laws and being misquoted. I've written 12 books. These are some of them. They're available on Amazon, my website, etc. Today, we're going to talk about this particular one. This is Tucker versus American Employers Insurance Company. And the topic always comes up as to whether or not you have the legal right to do surveillance on someone or not. This was a Florida case, and this is built on case law. So what you're going to see is one case establishes the law and then case law backs it up or changes it. In this particular case, the court held that because of the public interest in exposing fraudulent claims, plaintiffs should expect that a reasonable investigation would be conducted upon the filing of a claim. The investigator had been conducting surveillance on this particular person and they tried to use the topic of harassment, etc., etc. That, of course, did not go over, and that case upheld that. In Forrester versus Manchester, again, when a claim is made for personal injuries, that person must expect that a reasonable inquiry and investigation could be made into that claim. To this extent, that person's interest in privacy is circumscribed, and she is not entitled to the same degree of privacy that she would enjoy within the confines of her own home. So in this case, surveillance took place on an open public thoroughfare, and the court held that they could not maintain an action for invasion of her right to privacy. They also said the motion pictures or video were considered as a reasonable means of obtaining evidence. So it's not uncommon when you do surveillance to have to go to court or give a deposition, and part of that is one of these topics. You're going to have to testify to the fact that you did not preclude any laws. In Jenkins versus Rainier, the defense was allowed to protect the integrity of the film's contents by redeposing the plaintiff. The defense did not wish to disclose the contents of the surveillance films because of possible impeachment value. So, in essence, what the court upheld is that video is a legitimate means. It can be used as documentation, and in this particular case, the defense was trying to make sure that the integrity of the film's contents was available and that they were allowed to redepose the parties involved. So one case that I was involved in had a situation where the head of a law enforcement training academy was accused by one of the females in the training academy of rough jokes, inappropriate comments and behavior, etc., etc. So we did the investigation on that. And during the course of that investigation, I called some of her prior employers, and word got around to her, and she called up to the office and just, cussed me out and really said some harsh things. And so I stopped her and I said, look, you can't begin to think that you can make an allegation against a public figure. In this case, it was against a public official who would have been charged with misuse of his authority and position. I said, so you cannot begin to think that you can make a claim like that against a public figure and you're not going to be investigated. So essentially, this is kind of the same thing. If you're a claimant and you make a claim against an insurance company or a company, these cases are stating that you better just understand that they have the right to investigate you. Jim Bearden versus Honorable Pat Boone. This was a case in 1985 in Texas. The investigator did have authority to claim attorney-client privilege and is protected under the work product exemption. The attorney-client privilege belongs to the client, and once created, the privilege continues for as long as the client wants to assert it, and it is not affected by the resolution of the controversy. So that's what they were trying to breach, was the attorney-client privilege. And so whenever we get a subpoena, the first thing I do is reach out to the client. Because number one, they need to know that we're being subpoenaed so that they can object to it, they can try to overturn it, whatever the case may be. But they'll also tell you when you get that subpoena that you're to bring every invoice that you've ever created, every case list that you've ever created, et cetera, has nothing to do with this case. And so I tell my investigators, the only thing that you're going to take is the invoice and the actual report, which has already been made available to them. Outside of that, it's attorney-client privilege work product. So we don't provide that to them. Filomeno Dominio Hudson versus Dallas Wynn and Regional Investigators. This is again a 1993 court case out of Texas. A suit was brought against the private investigator and his employer for invasion of privacy and trespass. During the investigation, the plaintiff testified that she invited the investigator into her condominium and discussed her personal life with the investigator without any coercion by him. The court held that the plaintiff could not recover on the grounds that neither were licensed to conduct investigations in the state of Texas, where failure to acquire a license was not a proximate cause of any damages of injuries. So an investigator from outside of Texas came into Texas, did the investigation, and the court held in this particular case, even though they were not licensed, they were going to allow the information to be applied in this case. I'm sure they had problems with the licensing board after that, but it did not preclude that information from getting into court. During the investigation, the investigator, for whatever reason, went to the door and was invited in. So once you're invited in, they can never claim the trespass. In McLean versus Boise Cascade, the investigators conducted a minor trespass. I don't really know how you conduct a minor trespass. I mean, you just step your toe on the property and then step back. It's kind of like saying I kind of had a minor running red light. I don't know, but that's what it says. The court held that the significance of the evidence was important and that although the investigators trespassed a few feet on the plaintiff's property, that did not constitute enough of an improper action to find them guilty of trespass. Hall versus the state of Texas. This is the core to a lot of questions that you get asked on the stand or in a deposition. The court ruled that under Rule 1001, which governs admissions of photographs, including videotapes, the 7-prong test must be satisfied. And so when you get on the stand, they'll often say, investigator so-and-so, can you please tell me how you obtained that video? And so you have to say, yes, I saw the person outside, I raised my video camera, I turned it on, I hit the record button, I videoed, at the conclusion I hit the button again, it turned it off, and I have not edited the video. And so basically telling them what a monkey could do to operate a camera. But this is why. It says, it must be proved that the recording device was capable of taking testimony, that it was able to show that the camera was in good operating condition, essentially. The operator of the recording device must be shown to be competent and know how to use it, which is why you got to sit there and say, I turned the button on, I turned it off. The authenticity and correctness of the recording must be documented. In other words, you did not edit it. If you took portions out of it so that the court didn't have to watch 10 hours of video, then that's okay. But you also need to have the original available that's unedited. The investigator must be able to show that the tape or photographs have not been edited. The court must be shown the manner of presentations, video, photography, whatever, The recordings must show proper identification of the subjects, good facials, must be able to show that the testimony of actions was elicited voluntarily. So, in this business, I've been doing this since 1989 under my own company. And so, in the early days, it was not uncommon to have an investigator put a $10 bill on the sidewalk, so when the claimant came out, they had to bend down to pick up the money. Or they would let the air out of a tire so that they had to change the tire. That's, by anybody's standards, wrong. It's entrapment, and so you cannot elicit the testimony of somebody. I had lunch with an insurance adjuster one time that I had been using our services, and she said, well, you got a competitor in town, and they're really something. I said, really? Tell me about that. And he said, well, in this particular case, the claimant was outside, and so the investigator had a pickup truck and had a toolbox on the back. Apparently it was a junky toolbox or whatever, because it states in the report that they went down the road and they filled the toolbox with a bunch of rocks, and they put it on the tailgate so that when they went by the claimant's house, they kind of fishtailed and made it fall off in the road. And then they went down to the end of the road and videoed the person dragging it back onto their property. And so I had a good laugh, and I said, yeah, that's interesting. I said, but let's assume that the person was really injured and they were getting over their injury, and pulling that back over, they re-injured themselves. Or let's assume that they were not really injured in the first place and they were faking the claim, but they hurt themselves while doing that. And let's just assume that that's entrapment, which it is, so you're liable as an insurance adjuster, as is the investigator. So I said, I'm not really worried about that competitor, and obviously they're not around anymore. The Gramm-Leach-Bliley Act prohibits pretexting, the use of false pretenses, including fraudulent statements, and impersonation to obtain consumer personal financial information such as bank balances. So you can't call a bank up and say, hey, I'm John Doe, can you tell me how much money's in my account? Number one, banks won't do that anymore, and number two, it's illegal. And so it's also one of those scenarios that came out of a lot of pretexting for asset searches. And so, unfortunately, they had to enact a law for stupidity. The Electronic Communications Privacy Act sets out the provisions for access, use, disclosure, interception, and privacy protections of electronic communications. So, thus, you can't go around just, bugging people's phones and their communications and recording stuff. You have to have their permission. According to the U.S. Code, electronic communications means any transfer of signs, signals, writing, images, sounds, data, etc., etc., etc. So, like you, I'm sure if you've been an investigator very long and you have clients that go, look, I want to get into my spouse's emails and all their accounts and all this kind of stuff. Well, legally you cannot do that. And so now you have to explain that although a lot of those services are available and it's on the internet, those companies are traditionally offshore, which means they can't be easily prosecuted by American law enforcement. So while they're offering that service, the end user, which is you, the client, are the ones that's going to get prosecuted for it. So it's a little bit of education that you have to do with your client. The Telephone Recorder Records and Privacy Protection Act of 2006 amends the Federal Criminal Code to prohibit the obtaining of confidential phone records, information from a telecommunications carrier. So you cannot, as a spouse, call up AT&T or whoever and say, look, I want my husband's phone records. You cannot do that legally. Excuse me, I'm sorry. Unfortunately, people still do that. So now they go, well, we're on the same bill together. Well, that's a fine line. And, so I wouldn't do that because you're entitled to privacy. So in other words, even a computer at home, even though it's there, and there's case law which suggests that you may share a computer, but you have different logins. So if your spouse happens to leave that computer on and you walk up to it, you can't invade their privacy. So be careful with advising clients on any of those topics. You're not an attorney, nor am I. Truth in Caller ID Act of 2006 amends the Communications Act to prohibit manipulation of caller identification information. So, we all get these spoof calls now, and it looks like it could be your own number, or it could be your parents' number, or whatever. It's real easy through the spoofing software to do this. That spoofing software was originally designed for marketers to hide their identity and things of that nature. Well, understand that you cannot legally do that, and especially to solicit some type of information from people. It's several federal crimes involved in that. Freedom of Information Act, this is often misapplied for a lot of different reasons, but essentially it says that each agency, in accordance with published rules, shall make available for public inspection and copying copies of all records regardless of the form or format which have been released to any person under paragraph 3. So that's why if you ever want records from a government agency, quote the Freedom of Information Act. So they may be slow in doing it, which they're not supposed to do. It outlines in here how many days they've got, unless extenuating circumstances. In making any record available to a person under this paragraph, an agency shall provide the record in any form or format requested by the person if the record is readily reproducible by the agency. Fees shall be limited to reasonable standard charges. So I've had people, I had a police chief in a small town down in South Texas one time admit that he had a crash report. I just needed the police report. And he said, yeah, I've got the police report, but it's going to cost you $1,000. And I, after I almost fell down, I said, so let me get this right. You have the police report. And so all I have to do, I'll pay you something reasonable for it. I'll give you $50 for it. But if you don't provide me a copy of it, I already know you have it. You are required by law to give the state, the Department of Public Safety, a copy of that. So I'll eventually get it one way or the other. So I can either subpoena it, or you can give it to me at a reasonable rate. So, that was just manipulation. Attorney work product, again, in Weeks Marine Incorporated, the Court of Appeals of Texas, in the Fourth Court, back in the year 2000, stated that while a redacted form of the report may have been discoverable, the total report is privileged as core work product. In this particular case, the surveillance report that included photographs of the subject and the videotape are privileged as work product. The report contains the results of an investigation into the subject's background and summarizes surveillance activities. So this case, once again, points to the fact that if we're hired by an attorney, we can claim attorney-client work product. And so don't just hand stuff over to the other side. For whatever reason the documents in questions were initiated, they now represent documents prepared in anticipation of litigation. Martinez, in this case, the subject, may have been able to discover the documents in federal court, but he's subjected himself to Rule 192 by choosing to sue in state court. So, a bunch of legal stuff which basically says you can claim attorney-client work product. Drone and GPS laws. GPS are regulated by state to state. We'll talk about that in a second. Drones, they have federal and state regulations, but for the most part, you can't use them to spy on somebody's, in their backyard. Essentially what it's designed for is limited purposes. So if you have an accident scene, car accident scene, if you have an arson, something of that nature, you can send a drone up under certain circumstances. Most of the time you even have to file a flight plan for those. Drones have to be registered, and so if you have one and it goes down somewhere, it should be able to be traced back to you if you register them the way you're supposed to. So, difference between police and PIs. This always comes into question whenever I get into this topic. For the most part, police are required to obtain a warrant to install a GPS. PIs do not have that same requirement. Depending on the state that you operate in, there may not even be a law associated with this, or it may be like it is in Texas, where you have to have permission from one party who owns that car. So if a husband and wife jointly own that car, one spouse can give you better be written permission. And so I would tell you, always run the license plate, see who the registration comes back to. And then some states, including Texas, have a defense built into the criminal code. Our criminal code says that electronic or mechanical tracking device means a device capable of emitting an electronic frequency, basically a GPS. The motor vehicle is signed by the section, a person commits an offense if the person knowingly installs an electronic or mechanical tracking device on a motor vehicle owned or leased by another person. Get this in writing. It is an affirmative defense to prosecution. So I've had this conversation with a friend of mine that's a PI and an attorney. And he says, man, don't put GPS on your vehicles because you're going to get sued. Well, you can get sued for walking down the sidewalk. I mean, you can sue for about anything now. So our state code in Texas says that it's an affirmative defense to prosecution. Under this section, if the person obtained the effective consent of the owner or leasee, or they were a peace officer, assisted another person who was believed to be a peace officer, was a private investigator under Chapter 1702, our licensing code, and had written consent given by the owner or leasee of the motor vehicle. So some states, there's not a law. That's going to be rectified soon, I'm sure. But understand which state you're operating in and understand that there may be different laws. So laws related to PIs, understand that you can't trespass. You should know that already. You can't, when it comes to trash is one of those things that states when the trash gets to the street curb, it now becomes trash and it can be obtained by a PI or whoever. So that's one of those kind of things whenever you're going to do dumpster diving, make sure that it's at the street. I always tell my investigators, take video and photograph showing that it's at the street before you ever go up to do any dumpster diving, assuming that you do. Financial records, be very careful in any kind of pretexting that you do. Pretexting is a legitimate part of our investigation. So, in other words, if in undercover operations and everything else, if you tell somebody that you are a police officer, or if you tell somebody that you're a private investigator, chances are they're not going to cooperate with you. So there's times and points where you're trying to get information where a pretext might have to work. There's nothing illegal for a private investigator to do that, as long as they're not soliciting personal information, such as phone records, bank records, things of that nature. Understand that in this day and age, you need to make sure what your insurance policy says, because there's certain things where you will not be covered. Pre-employment background investigations, that's one of those areas that you got to make sure that you are 100% knowledgeable on the laws pertaining to background investigations, because there is a difference between conducting an investigative background and a consumer investigation. A consumer investigation is one that falls under pre-employments. You cannot use databases like TLO, Clear, all the databases that we use as investigators. You cannot use those to do pre-employments. And coming back to that, before I forget, you also are not supposed to give a client just a full copy of the TLO report or the tracer report or whatever it is. You can take bits and pieces out of it, but you cannot give them contractually. Your contract says that you cannot give that to a third party. So also be aware that when you're doing investigations and you're doing it for attorneys, they have access to a lot of these same databases that we have access to. So if you're going to bill them $500 and give them a comprehensive report, understand that they already know how much that costs, and you probably will never hear from them again. So back to the consumer reporting agency, a pre-employment has so many laws affiliated with that. And so I've been sued twice in my PI career. Once was a federal case in which we did surveillance on a person that was civil service for the Air Force. In that particular case, he sued everybody that worked with him and the JAG officer, attorney. And in this particular case, he tried to say that we trespassed and that we were using these high-powered cameras. Well, you can see our investigator in his vehicle, and he's in a church parking lot, and he pans, and you can see the marquee of the church, you can see the hood of the car, you can see the street, you can see the barbed wire fence, and then you can see our guy on a tractor. And so we had to produce the actual camera to show that it was just a standard off-the-shelf camera. That case was dismissed. The other case involved a pre-employment that we did. And in that particular case, they tried to say that our client did not give them the proper opportunity to contest the charges. And they tried to say that we provided charges that were not properly evaluated and that should have been redacted, et cetera, et cetera. So that was settled for a nuisance value. And so understand that doing pre-employment background searches, there's a lot of stumbling blocks in there. So if you're going to go into that type of our business, make sure that you talk to people that do it. Make sure that you have a full understanding of what you can and cannot do. So as always, I appreciate you. Thank you for attending this seminar, and hope to see you in some of my other ones. Thank you.